Welcome to While We Were Distracted, the podcast where we explore topics that often get overshadowed in the rush of daily life.
So imagine you're just hanging out on a beach.
Right, nice and relaxing.
Yeah, exactly. And you pick up a few random seashells, you arrange them in the sand to form a couple numbers, maybe snap a picture and post it to Instagram.
Just a completely mundane vacation moment.
Totally. But now imagine that, like, a year later, the Secret Service is literally knocking on your door.
Oh, wow.
Yeah. And that single random photograph of seashells actually becomes the catalyst for a federal indictment.
I mean, it sounds absurd. It sounds almost like a glitch in the simulation or something.
It really does.
But that is exactly the reality we are looking at today. We are literally watching a social media post mutate into a full-blown constitutional crisis.
Well, welcome to today's deep dive. Today is April 28th, 2026, and the news cycle is absolutely on fire.
It is wild right now.
It really is. And we've got a massive stack of sources today. We're looking at breaking news out of the Eastern District of North Carolina, federal court rulings from Manhattan, Inspector General reports, and really the whole dense legal history surrounding the ongoing federal prosecutions of former FBI Director James Comey.
Right. And our mission today is really to help you, the listener, just cut through all the partisan noise.
Because there's a lot of it.
So much. We are going to map out the actual legal architecture here. The behind-the-scenes procedural warfare, and, the fundamental constitutional questions about executive power that are really at the center of this whole saga.
Yeah, because the headlines you're seeing today, they're just the surface level.
Exactly. The real story is this invisible machinery of the justice system, like how it operates under intense pressure and what happens when the people running that machine just start, ignoring the safety manuals.
Okay, but before we jump in, we want to make it absolutely clear to you that the sources we are exploring today contain highly politically charged content involving both left-wing and right-wing figures. Right. And that includes President Donald Trump and former FBI Director James Comey. We are not taking any sides. We are impartially reporting on the content provided in our stack of sources to convey the original ideas, and we are not endorsing the viewpoints of any political figure or the source material itself.
Absolutely.
Okay, let's unpack this.
Well, we really have to start with the bombshell that dropped just this morning. James Comey has been indicted again.
Okay.
Yes, again. This time in the Eastern District of North Carolina.
And the spark that actually ignited this brand new federal charge is that beach photograph we mentioned.
Yeah, the seashells.
Right. So last year, Comey posted a picture on his Instagram of some seashells arranged to form the numbers 86 and 47.
And he deleted it almost immediately, right?
He did. But, the internet is forever.
Yeah.
And the interpretation of those specific numbers was just instantaneous and completely explosive.
Yeah, so Trump supporters analyzed the post and basically concluded that 47 referred to Donald Trump since he's the 47th president.
Okay, and what about the 86?
Well, the 86 was interpreted using restaurant industry slang.
Oh, right, like when a kitchen runs out of something.
Exactly. If a kitchen 86 is a dish, they get rid of it. They toss it out.
Wow.
So this public narrative rapidly crystallized that a former FBI director was covertly signaling a call to eject, remove, or, even eliminate the president.
And this didn't just stay on the internet. It went straight to the top of the government.
It really did. Kristi Noem, who was the Homeland Security Secretary at the time, actually went on the record claiming Comey had just called for the assassination of the president.
Which is a massive accusation.
Massive. She actually deployed the Secret Service, and agents sat down and formally interviewed Comey about these seashells last May.
Which brings us to the actual mechanics of how a social media uproar becomes a literal federal case. Because Comey followed up that deleted post by explicitly stating he didn't realize those numbers had violent associations.
Right. He firmly stated his opposition to violence.
So hold on. I'm stuck on this exact point. He deleted the post. He publicly clarified his intent. He literally spelled out that he opposes violence.
Yes.
How does an ambiguous arrangement of shells translate into a federal prosecutor walking into a grand jury and actually securing an indictment? I mean, that leaps over so many legal thresholds. It's like getting a federal indictment over a cryptic bumper sticker.
What's fascinating here is that you cannot view this North Carolina indictment in a vacuum. You have to look at the immense pressure building on the prosecutors themselves.
Okay, so what was going on behind the scenes?
Look at the timeline. Back in September 2025, President Trump posted on Truth Social directly urging then Attorney General Pam Bondi to stop delaying.
Oh, so he was publicly demanding action.
Exactly. He specifically demanded action against Comey, New York Attorney General Letitia James, and Adam Schiff, and he declared them, quote, guilty as hell.
So these prosecutors are operating under this immense, very public mandate from the executive branch.
Yes. So the Seashell indictment isn't an isolated event. It's really a continuation of a legal war that started years ago.
Which means, to understand the ferocity of today's indictment, we really have to look at the wreckage of the government's first attempt to prosecute Comey.
Oh, absolutely. It was a spectacular collapse, and it really explains why the Justice Department is taking such aggressive, unconventional swings right now.
Okay, let's pull out the files from September 2025 in Virginia. This was that first indictment.
Right, the perjury charge.
Yeah. The grand jury charged Comey with making a false statement to Congress and obstructing a congressional proceeding. And this all traced back to a Senate Judiciary Committee hearing from way back on September 30th, 2020.
Right, so the government's entire perjury case here basically hinged on a single exchange with Senator Ted Cruz.
Just one exchange.
Just one. Senator Cruz asked Comey about authorizing anonymous leaks, and Comey said no.
Okay.
So the prosecution alleged that that was a lie. Because according to their theory, Comey had actually authorized his friend, this Columbia law professor named Daniel Richman, who they referred to as Person 3, to leak information regarding the Clinton investigation to the press.
Now wait. On the surface, perjury seems incredibly straightforward.
You'd think so.
Like, you sit in the chair, you swear an oath, and if the words coming out of your mouth don't match the facts, you committed a crime. It's pretty black and white.
Usually, yes.
So why did Comey's defense team attack this by calling Senator Cruz's question fundamentally ambiguous?
Well, this gets to the very core of how perjury statutes actually operate in the real world. The law requires extreme precision.
So you can't just have a vague question.
Exactly. A witness cannot be convicted of perjury if the question itself is tangled or, open to multiple reasonable interpretations.
Oh, interesting.
And Comey's lawyers pointed out the broader context of that Senate hearing. Senator Cruz had been aggressively questioning Comey about former Deputy Director Andrew McCabe, and specifically McCabe's well-documented leaks to the Wall Street Journal.
Oh, so Comey's defense argued he was actually answering a question about McCabe's leaks, not his own.
Precisely. And since Comey didn't authorize McCabe to leak, his answer of no was literally true.
Wow. Literally true.
Yeah, legally speaking. If an answer is literally true based on a reasonable understanding of a sloppy question, the perjury charge just evaporates.
That is a huge legal distinction.
It is. And furthermore, the FBI had actually already investigated this exact dynamic.
Wait, really? When?
Back in 2017, they ran this internal probe called Arctic Haze looking into leaks. And they actually interviewed Daniel Richman directly.
What does he say?
Richman told federal investigators that Comey never asked him to talk to the media. That Arctic Haze probe closed in 2021 with 0 charges, specifically finding insufficient evidence that anyone lied.
So let me get this straight. The government is trying to build a perjury case on a foundation they already thoroughly inspected and condemned years prior.
Pretty much, yeah.
But, from the sources, the weakness of the charge isn't even the wildest part.
Oh, not even close.
It's the absolute procedural chaos that happened behind closed doors when they tried to ram this indictment through.
Right, because the calendar was their biggest enemy here. They were operating in September 2025.
And the statute of limitations on Comey's 2020 testimony was set to expire on September 30th.
Yes, they had literally days left before the case permanently expired.
And the career prosecutors who had been working the case, along with the interim U.S. Attorney for Virginia, Eric Siebert, they looked at the Arctic Haze files, they looked at that literally true defense, and they decided they didn't have a case.
Right. They actually drafted a declination memo. They were ready to just walk away.
But Siebert was pressured into resigning just days before the deadline.
Right. And then the Justice Department parachuted in Lindsay Halligan to replace him.
Who is she?
Well, Halligan is a former personal defense attorney for Donald Trump and a White House advisor. But crucially, she had 0 experience as a criminal prosecutor. None.
Wow.
She took over on September 22nd. 3 days later, she secured the indictment.
Honestly, it's like a police officer pulling you over and writing you a massive speeding ticket, but then you find out later they aren't actually a cop. They just, bought a uniform online and jumped in a cruiser because the real cops refused to write the ticket. It completely undermines the authority of the whole action.
It does. And because Halligan was rushing so fast to beat the buzzer, the actual grand jury process became a mechanical disaster.
Because grand juries have very specific rules.
Incredibly specific. They aren't there to just rubber stamp a prosecutor's vibe, you know? Their constitutional role is to review the evidence and authorize the specific charges.
But Halligan kept the jurors past normal hours.
Yeah, late into the night. And the jurors actually rejected one of the proposed charges, which forced Halligan to frantically draft a revised indictment.
And she signed 2 different versions of the revision.
Yes.
And here is where the machinery completely breaks down, according to the transcripts. The full grand jury never even laid eyes on the final revised indictment.
No, she only presented it to the foreperson.
Which triggered a massive judicial backlash.
Oh, absolutely. U.S. Magistrate Judge William Fitzpatrick rebuked the Justice Department in a way you just rarely see.
What did he do?
He ordered the release of the grand jury transcripts to the defense. That is an incredibly rare move.
I bet.
And Judge Fitzpatrick explicitly called out the DOJ for running a highly unusual, quote, indict first, investigate second strategy.
Because the evidentiary foundation was just crumbling everywhere.
Huh.
Over in D.C., District Court Judge Colleen Collar-Cotelli blocked the Justice Department from using evidence they had pulled from Daniel Richmond's personal computer.
And do you know why?
Because the government didn't even bother to get a new warrant. They tried to recycle an old warrant from a closed investigation.
Which is a massive violation of the Fourth Amendment. So you have bad evidence, a botched grand jury, and a weak underlying charge.
Right.
But none of that was actually the fatal blow.
Okay, go Wes.
The real kill shot to the 2025 indictment was about whether Lindsay Halligan even had the legal right to be in the prosecutor's chair in the first place.
So on November 24th, 2025, senior U.S. District Judge Karen McGowan Curry dismissed the indictments of both James Comey and Letitia James without prejudice.
Yeah.
And it all hinged on the Appointments Clause of the Constitution, specifically a statute known as 28 U.S.C. Section 546.
The 120-day rule.
Break that down for us.
So this is a phenomenal example of how procedural rules are the actual bedrock of government checks and balances. The Constitution requires the Senate to advise and consent on presidential appointments, right?
Right, they have to approve them.
But vacancies happen. So Congress passed this law saying the Attorney General can appoint an interim U.S. attorney to just keep the office running. But that power expires after exactly 120 days.
Because if the president could just appoint interims endlessly, they could completely bypass the Senate confirmation process altogether.
Exactly. So after 120 days, if there's no Senate-confirmed nominee, the power shifts. The local district court gets to select the temporary U.S. attorney.
And in the Virginia district, that 120-day clock had actually started ticking way back in January when Eric Siebert took the job.
Yes. So the attorney general's power to appoint an interim evaporated on May 21st.
Meaning, when they installed Lindsay Halligan in late September to rush this indictment.
She was legally a ghost.
Wow.
Her appointment was void. Judge Curry ruled that every single action she took was a legal nullity. She simply had no authority to sign the document.
That is incredible. And the legal footwork by the defense to expose this was just masterful. Comey's defense attorney, Pat Fitzgerald, filed these motions to dismiss, and the legal writing was just immaculate.
Oh, Halligan was completely outmatched.
Totally. And in her scramble to save the case, she actually tried to weaponize a procedural tool called a taint team.
Right, the filter team.
Tell us about that.
So a taint team is supposed to be a shield for the defendant. When the government seizes a computer, a separate group of prosecutors reviews the files to filter out anything protected by attorney-client privilege.
So the main prosecution team doesn't accidentally see privileged material and taint their own case.
Exactly, it's a protection.
But Halligan missed a deadline regarding this filter process. So to justify expediting it, she turned this protective shield into a sword.
Yeah, this part is wild.
She filed a motion falsely accusing Pat Fitzgerald of being complicit with Comey in criminally leaking classified information years ago. She essentially tried to smear the opposing counsel with a baseless felony accusation just to bypass a paperwork deadline.
It was such a reckless accusation, primarily because the defense had the receipts ready to go. A 2019 Inspector General report had already exhaustively investigated that specific claim.
And what did they find?
They concluded there was zero leaking of classified information by Comey or his counsel. The DOJ had formally declined to prosecute years earlier.
So using it in 2025 was just transparently viewed by the court as a bad faith delay tactic.
Totally. The DOJ was cornered. And when they realized they were losing on the 120-day rule, they tried to invent a retroactive loophole.
Of course they did.
They issued a memo weeks later claiming Halligan wasn't actually an interim U.S. attorney. She was a, quote, special U.S. attorney exercising the attorney general's broad general power.
But Judge Curry dismantled that argument immediately, right?
Right. Immediately. Because if we connect this to the bigger picture, if the court accepted that logic, the entire concept of Senate confirmation would be meaningless.
Right.
It would mean the Justice Department could literally pull any private citizen off the street, have them run a grand jury, secure an indictment, and legitimize it later as long as the Attorney General stamped it after the fact.
Which would completely obliterate the institutional guardrails of the justice system.
Absolutely.
But, as we've seen, when procedural shortcuts and retroactive loopholes failed, the aggressive use of executive power didn't stop. It just shifted targets.
Yeah, the legal war basically turned into a personal purge.
Let's talk about the collateral damage, because it began stacking up quickly. In January of 2026, Robert McBride, who was the #2 federal prosecutor in the Eastern District of Virginia, was abruptly fired.
And the reported reason? He refused to lead the reprosecution of James Comey.
Which brings our timeline crashing right back into today, April 28th, 2026. Because this personnel purge has gotten deeply personal.
It really has.
We are now reading reports out of Manhattan about Maureen Comey.
James Comey's daughter.
Yes, his daughter. But more importantly, she is a highly respected senior trial counsel in the Southern District of New York.
Right.
She literally just successfully prosecuted Sean Diddy Combs on major trafficking charges. And shortly after securing that massive victory, she was fired without cause.
So she has filed a wrongful termination lawsuit alleging that she was fired in direct retaliation against her father.
Let's look at the mechanics of this. Because firing a career prosecutor who just won a high-profile trafficking case without citing a single performance issue is wild.
It is unprecedented.
How does the government even attempt to legally justify that in a courtroom?
Well, they are leaning on a constitutional theory known as the unitary executive theory. Specifically, a maximalist interpretation of Article 2.
Okay, Article 2, what does that say?
Article 2 of the Constitution vests all, quote, executive power in the president. So the government's argument is that because the president is the ultimate head of the executive branch, every single executive branch employee, including career prosecutors, serves entirely at his pleasure.
Wait, so they are arguing that civil service protections, standard HR policies, administrative reviews, all of that is unconstitutional if it restricts the president's absolute right to fire anyone in the executive branch.
Precisely. They are using this maximalist theory to argue her firing was a lawful exercise of presidential power.
But didn't a judge just rule on this today?
Yes. Today, Judge Jesse M. Furman ruled that Maureen Comey's lawsuit belongs in federal court, not hidden away in some bureaucratic administrative proceeding.
Why federal court?
Because the government actually invoked Article 2, so this is no longer just a standard employment dispute. It is a fundamental constitutional showdown over the separation of powers.
Wow, and that ruling beautifully ties this entire deep dive together.
It really does. It's the through line of the whole story.
Because every single facet of this saga we've explored today is fundamentally about the tension between absolute executive power and the institutional guardrails built to constrain it.
Exactly.
I mean, we started with a picture of seashells on a beach.
Right.
And from there, we traced a path through rush indictments, blown statute of limitation deadlines, a completely bypassed grand jury, the weaponization of a taint team, a 120-day expiration clock on a temp job, and now the retaliatory firing of family members justified by Article 2.
It's a lot to process.
It is. And why does this matter to you, the listener? Because whether you're navigating complex corporate policies, studying law, or just trying to make sense of the breaking news alerts on your phone, this entire ordeal proves one critical point.
And what's that?
Procedural rules are not just bureaucratic red tape. They are the ultimate foundational safeguard against unchecked power.
Absolutely. When the rules are ignored, whether it's, how a question is phrased in a Senate hearing or how a prosecutor is legally appointed, the integrity of the entire system begins to warp.
So what does this all mean?
Well, if we step back and look at the bigger picture, it raises an incredibly important question, and it's actually something I want to leave you with today.
Go for it.
We've spent this entire deep dive analyzing how the courts handle procedural mechanics and how they check executive overreach. But consider this. What happens to the bedrock of our justice system when the court of public opinion, whipped into a total frenzy by a few cryptic numbers posted on an Instagram feed, begins dictating the timeline, the targets, and the actual behavior of federal prosecutors?
Are we operating on statutes and evidence, or are we just reading tea leaves in the sand?
Exactly.
Well, thank you for joining us on this deep dive. Keep questioning the narrative, look past the headlines, and we'll see you next time.
Don't forget to like and subscribe for the next episode on While We Were Distracted.